Arkansas holds a unique and somewhat controversial position in American landlord-tenant law. It is one of the very few states that does not fully recognize the implied warranty of habitability. If you're a landlord in Arkansas, this distinction matters enormously, and if you're a tenant, it's something you absolutely need to understand. For many years, Arkansas was the only state in the country that explicitly did not impose an implied warranty of habitability on residential landlords. The Arkansas Supreme Court declined to adopt the doctrine, and the legislature did not enact a comprehensive habitability statute. The prevailing legal framework was rooted in traditional property law. Essentially, the tenant took the property as they found it, and the landlord had no general obligation to make repairs unless the lease specifically required it. That landscape has shifted somewhat in recent years. In 2019, Arkansas enacted Act 1052, which created the Arkansas Residential Landlord-Tenant Act, found in Arkansas Code Title 18, Chapter 17. This was a significant development because it was the first time Arkansas had a comprehensive landlord-tenant statute. However, and this is the critical point, the act is considerably more limited than what you'd find in most other states. Under the Arkansas Residential Landlord-Tenant Act, landlords must comply with applicable building and housing codes that materially affect health and safety. You're required to maintain the premises in a fit and habitable condition, make repairs necessary to keep the dwelling in compliance with applicable codes, keep common areas in a reasonably safe condition, maintain electrical, plumbing, sanitary, heating, ventilation, and air conditioning systems in reasonable working condition, and provide running water and reasonable amounts of hot water. On paper, that looks similar to what other states require. But the key difference is in the remedies and enforcement. Arkansas gives tenants far fewer tools to enforce these obligations than most other states. When a habitability issue arises under the Arkansas Act, the tenant must provide the landlord with written notice of the problem. The landlord then has a reasonable time to make the repair. The statute doesn't define a specific number of days for most conditions, so courts evaluate reasonableness based on the circumstances, including the severity of the issue and the complexity of the repair. If the landlord fails to act, Arkansas tenants can pursue limited remedies. They can file a lawsuit for damages in court. They can seek a court order requiring the landlord to make the repair. And in cases where the noncompliance is material and affects health and safety, the tenant may be able to terminate the lease after providing proper notice. Here's what Arkansas does not provide. The state does not have a rent withholding remedy. Tenants cannot stop paying rent over a habitability issue. Arkansas does not have a repair and deduct remedy. Tenants cannot make repairs and subtract the cost from rent. And there is no formal rent escrow process where tenants can deposit rent with the court. These are significant gaps compared to most other states. The absence of these remedies means that Arkansas tenants who face habitability issues are largely limited to going through the court system, which can be slow and expensive. For tenants in lower-income housing, who are statistically the most likely to encounter habitability problems, the practical barriers to enforcement are substantial. Arkansas's climate creates real maintenance demands despite the lighter regulatory framework. Summers are hot and humid, creating conditions ripe for mold growth, pest infestations, and moisture damage. The state sits in an active severe weather zone, with tornadoes, thunderstorms, and occasional ice storms posing threats to structural integrity. And while winters are milder than in northern states, temperatures in the Ozark region and northern Arkansas can drop below freezing for extended periods, making heating systems essential. Local codes provide an additional layer of regulation in some parts of the state. Little Rock, Fayetteville, Fort Smith, and other larger cities have their own building and housing codes with inspection and enforcement mechanisms. In these municipalities, tenants can file complaints with local code enforcement, which can inspect the property and order the landlord to make corrections. But in rural Arkansas, which covers a large portion of the state, local code enforcement may be minimal or non-existent, leaving tenants with even fewer practical options. One practical consideration for Arkansas landlords. Even though the state's legal framework gives you more latitude than most, that doesn't mean you should take a hands-off approach to maintenance. Poorly maintained properties lead to higher turnover, longer vacancy periods, and eventual deterioration that costs far more to fix than ongoing preventive maintenance. The business case for maintaining habitable conditions exists regardless of what the law requires. Arkansas does have anti-retaliation provisions under the Residential Landlord-Tenant Act. Landlords cannot retaliate against tenants for making good faith complaints about habitability to government agencies or for exercising their rights under the Act. While the protections are narrower than in more tenant-protective states, they do exist, and courts will enforce them. For the complete guide to Arkansas habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.